And here we are continuing the opposition in downtown Memphis at Ozment and Copeland. And Robert, would you like to start the interview?
I would. Good afternoon, ladies and gentlemen. We're here in Memphis, Tennessee at the firm Ozment and Copeland. I'd like to introduce you to the Lieutenant Colonel for Criminal Defense of the Western Section of the State of Tennessee, Joe.
Hello. Joe Ozment.
Tell them what you think about this amendment.
I think the amendment, I'm curious as to where it came from. Obviously, Tactile filed a fee petition several months ago, or last year, seeking increase in pay of indigent lawyers, primarily because the indigent lawyers are being paid at 1992 rates, which is the last time, 1992 I believe, or 1994, somewhere there, that the rate was increased from $28 an hour out of court, $30 an hour in court, to $40 and $50. Since then, the people that work for administrative officers of the courts have all had raises. The judges have all had raises. The prosecutors have all had raises. The public defenders have had all raises. Pretty much everybody in state, federal, city government have had raises. Inflation has occurred. Gas prices are approaching $4 a gallon now. The cost of maintaining an office has gone up. And, you know, basically what this is, I feel like, is the response of the AOC to the fact that Tactile and TVA and whoever else said, hey, you know, you're forgetting about these indigent defense lawyers. Well, all AOC is thinking about is trying to find a cheaper way to do it, because apparently paying, in their eyes, I guess paying $40 and $50 an hour is too much. They want to get some young attorney possibly out here that would work for some contract rate and handle so many cases where they can be paying him $20 or $30 an hour. And that might work for the first couple of years of his law practice, but he's not going to be able to maintain a law practice or provide good criminal defense just with himself and no employees, because of the amount of money that he would be making, there's no way to provide that. There's a lot more involved than working out of your house as a lawyer, and if that's the culture of lawyers they want to create to represent indigent defendants, it's a sad day for indigent defense. The bigger trouble is, how's this rule going to work? What's the process of being a contract attorney? What are the limits on what they can, or what's the minimum they should have to pay somebody? How many cases is that person going to have to handle for that price? I don't know. It's just, to me, to even say we should have a rule that even allows something similar to this, the rule would need to be a lot more detailed as to how it works, because right now you've got just somebody at AOC, I guess the director can just randomly decide how this rule is going to work.
Do you feel comfortable with that moving forward with your practice?
My practice would do a good bit of indigent defense. Certainly, you know, my practice, you know, some lawyers, I don't know how without their practice would be okay without the indigent defense or not on the court-appointed work. You have a lot of attorneys in this state, and all of them, I think the best way to refer to them is small businessmen. They have maintained small law offices across the state, and just like any other, you know, you have your clients that are not court-appointed that hire you, and you also have your cases that you're appointed on where you represent people. But essentially, you're running a small business in this state.
Joe, you've read the rule, and it talks about workload requirements. And you mentioned a very important point, and that is the private mix versus the appointed mix. Are you clear on what the AOC would have access to regarding your private cases in order to determine your adequate workload with the way this rule is written?
I've never had AOC request one of my files. From my understanding, they have requested other attorneys' files. I don't know. I have a very serious problem with that. If I am representing little Tommy, who carjacked somebody in Memphis, Tennessee, and his mother Patricia's paying me, when little Tommy's case is over, Patricia can't have my file. I have attorney-client privilege with little Tommy. And unless little Tommy says, give my file to my mother, I can't do that. And you know, quite frankly, I don't want to think of AOC as the mother of any of my clients.
or the mother of you, for that.
And I don't think, yeah, or the mother of me. I mean, it's just not, you know, they don't have a right to that information. there is attorney-client privilege, and you know, I think all that is problematic if somehow they're auditing people using some kind of standard that nobody probably even knows what it is. And when they do this, the way this rule looks is there's no real standard for them to follow as to how this works, who they choose, what kind of experience they have to have. You know, you have trouble right now getting. I mean, I know attorneys that won't take court appointments because it doesn't pay enough. I know attorneys that only take federal court appointments because in the state system it doesn't pay enough. And most of these are your better attorneys that are, you know, if you're arrested for something serious, that's a lawyer you would want to have representing you.
Well,
You know, and quite frankly, there are a lot of good public defenders out there, and there's a lot of good court-appointed lawyers out there, but to try to minimize what you're paying them for solely the state budget is not going to result in good attorneys doing good criminal defense for clients. You're going to have more people that aren't going to take appointments, and you're going to be left with a class of attorney that either doesn't know what they're doing, is a brand new lawyer, or it's not worth it in their law practice to handle a case where they lose money.
Two specific questions, Joe. One, do you see this amendment as promoting experience or non-experience inside the criminal defense system?
Again, I don't think you're going to have lawyers that are established attorneys that want to work as a contract attorney necessarily for ALC to represent people at a rate less than what they're already paying at $40 or $50 an hour, which I think is what this rule is trying to accomplish. It will pay you X amount to handle a number of cases. Now, you know, quite frankly, I like flat fees. In our private practice, we use it all the time. But I set my flat fee, okay? I decide whether I'm going to represent somebody for a certain price, and usually it's after I've interviewed the client. It's after I have an idea of what this case is about and how complicated this case is going to be. It's whether or not I have an idea of whether or not this case is probably going to have to go to trial, or this case is a case that could probably be settled. And you know, I set my fee on that basis. And sometimes that fee is $500, and sometimes that fee is $25,000.
Sure.
And that depends on what you're doing and what type of case it is, and to pigeonhole cases into a flat contract rate is not realistic.
No.
Because some cases you're going to have to put a lot of work into, some you're not. It's just not realistic. You know, there might be a way to have a flat rate system, but this rule I don't think is it, and it certainly doesn't spell out how that would work.
Do you think that this amendment to this rule would apply to criminal defense indigent bar would result in additional post-convictions and appeals, other additional costs that might not be?
I don't know if it'll result in any additional post-convictions. Anybody that gets a long sentence typically is going to file a post-conviction. I think certainly it might give someone in a post-conviction argument as to whether or not this attorney really put any effort into their case, or whether or not they were overworked or had too many cases in their caseload. Things of that nature that might occur when you start going in a direction such as this.
Anything else you'd like to say about the proposed amendment?
Without more details about the amendment, I think the only answer anybody should have is on this is be against it, certainly if you're an attorney.
Now, when you say without knowing more about it, would that be knowing more about it from the standpoint of the language in the rule itself, or from the verbal notifications of intent behind it?
I would suggest that the verbal notifications, the comments are worthless. We all know this from looking at a comment on a statute. So I just think the comments, yeah, well, it's a comment, it's not the law. It's a comment, it's not the rule. You know, if you want to have a system that does something like this, put a rule together that spells out how it's going to work, where people can make an informed judgment as to whether or not, well, yeah, that might work, yeah, that might not work. Or right now it's so vague that it's a very dangerous rule because you don't know what's going to happen here. You would hope that whoever's administering the rule would do it in a manner that would be good for indigent defense, but there's no way to see how that would work, and it's very, very concerning.
And one final question, Joe. Who is in a better position to match legal skills to particular case types? The judge in the local jurisdiction, or the director of the AOC in Nashville?
I don't think there's any question that the judges know who the good lawyers are that are actually doing a good job for their clients, and who the lawyers are that aren't doing a good job for their clients. The way this rule seems to work is that the judge would be required to give the case to a contracted lawyer. The contract lawyer might not be the most qualified lawyer to handle that matter. And you know, the judges have a duty, I think, to, when they appoint someone to represent a client, an individual that's indigent, they have a duty to appoint who they feel is a qualified lawyer that will do a good job for that client. That's a duty to the justice system. That's almost goes to the core of indigent representation. Is the judge, in some aspect, even though he's got to be a neutral judge, has to look out and make sure that everybody in his courtroom is doing a good job for their client if they're appointed, or and you know, the judge, because the judge basically is not, the client's not able to choose who their lawyer is. The judge is making this selection for them. And incumbent in that is making sure a good lawyer is appointed. If you go to this contract system, the judge is only going to be, but the way I read it, is going to have to go to whoever the contract lawyers are. They may not be, as I said, they may be new lawyers that aren't qualified to do a jury trial or a murder case. Even if it's a non-capital murder case, they may not be qualified to do a jury trial on any felony. They may not even have any jury trial experience. There's no standard here as to who are going to be these contract lawyers.
And of course, there is the opportunity for the director of the AOC to issue the policies and procedures that would dictate those things. You feel comfortable with that?
It needs to be in the rule. AOC certainly has a job to do, and that's watched, I guess, the purse strings, so to speak. Certainly they have responsibility to the citizens to try to spend the money wisely, but sometimes you know, you can't have the fox guarding the hen house, so to speak, and it seems to me that if this rule is going to be passed by the court as to how indigent defense is going to work, it needs to specify how that rule is going to be applied. It does not need to be in the hands of a bureaucrat that's job is to spend as little money as possible, because you know, that's just not a good way to marshal justice. And again, somebody in Nashville behind the desk doesn't know who the qualified lawyers are in Memphis, Tennessee. The judges sitting over in these courtrooms do, and they're the ones that have the duty to appoint qualified people who represent these people. And the contract lawyers may not be that person.
Anything else you'd like to say, Joe?
That's it.
Ladies and gentlemen, Joe, thank you very much for your time, Joe. Joe Ozment, Lieutenant Colonel, Criminal Defense Bar for the Western 2nd Tennessee. I'm Robert Foster, your Commander-in-Chief. If you're watching this, you are the opposition.